Good morning to everyone, and welcome to the University of Montana and this event hosted by the University of Montana School of Law. My name is Anthony Johnstone, and I have the good fortune to teach constitutional law at the School of Law, and it's my privilege to welcome you today to the Supreme Court hearing of the case of Donaldson and Guggenheim versus the state of Montana. I should say at the outset that in my last job I had the honor of representing the state of Montana in several cases, including this one in the lower court. But today I want to preview the arguments for you by introducing first our Constitution, then the courts, and then this case. I'll begin with our Montana Constitution. In 1972, 100 ordinary Montanans from all walks of life proposed an extraordinary document, our Montana Constitution. And after public debate and popular vote, we Montanans approved it by the narrowest of margins. It is a strong document that accomplished, or aims to accomplish, what it says in its preamble. We, the people of Montana, grateful to God for the quiet beauty of our state, the grandeur of our mountains, the vastness of our rolling plains, and desiring to improve the quality of life, equality of opportunity, and to secure the blessings of liberty, for this and future generations do ordain and establish this Constitution. And every 20 years, we, the people of Montana, get to renew our commitment to this document, and in 2010, we did. One of the most important constitutional rights we have under our Constitution is the right to see our government at work, and that's what we're going to do today in seeing the court at work. The primary role of the Constitution is to put government in motion. Through three branches of government that put the Constitution through work, through officials who are sworn to uphold the Constitution. Those three branches are the legislature, our state senators and representatives, and the people who write the laws, the executive, our governor, our attorney general, and other state officials who enforce the laws, and our judiciary, including our Montana Supreme Court, who apply the laws by deciding cases like the one we will hear today. In our federal system, there are two levels of courts: federal courts and state courts. And our federal courts are headed by the Supreme Court of the United States in Washington, D.C. And we are very fortunate to have the clerk of the U.S. Supreme Court joining us today, General William Souter. Now, federal courts generally hear questions arising under the U.S. Constitution and federal laws, which are laws enacted pursuant to the limited powers of the federal government. But most laws are state laws. Most courts are state courts. And state laws and courts have by far the greater impact on our day-to-day lives. In Montana, our courts see 1,000 cases per day. Hundreds of thousands of cases each year are filed. Those courts begin in the trial courts, where trial judges and juries hear those cases and decide them. Now, at that stage, for those of you who are unfamiliar with our legal system, those cases look a lot like what you might see on television. Lawyers present facts, evidence through witnesses and documents, and make legal arguments for why their client should win by applying the law to those facts. The lower courts then decide the cases based on the facts and the law. Now, in a few hundred of those cases each year, the losing side disagrees with the decision and decides to appeal the case. When you appeal a case from the district courts in Montana, you go directly to the Montana Supreme Court. As I said, there are a few hundred of those cases each year. About half of those cases involve civil matters like personal injury or contract disputes, usually between individuals or businesses. About a third of those cases involve criminal matters like drug trafficking, thefts, assaults, or homicide. And the remaining cases involve family matters like divorce or child custody disputes. Now, when those cases reach the Supreme Court, as you'll see, there are no witnesses testifying to facts, only lawyers arguing the law. Most of these cases pose the question of whether one party or another has followed or violated the law that our legislature or we the people have made through the initiative process. The legislature makes its laws in its biennial sessions. But a few cases, rather than posing the question of whether someone has followed or violated those laws, pose the question of whether the laws themselves are illegal or unconstitutional under the Montana Constitution. And the case today asks this sort of question about our state laws. In other words, if a state law violates the higher law that we the people have made, the Constitution, the lower state law made by our representatives is invalid. When we the people of Montana formed our state government, we gave the government certain powers and duties, like the power to tax us, to make laws, the duty to fund schools. But we the people also retain certain rights from our government. Rights like the freedom of speech, the right not to have government take your property without compensation, or the right to bear arms. The Constitution, in other words, when we the people give powers and retain rights, is a deal we the people have made with our government through which we govern ourselves. Now, one way, the most common way we the people hold our government to this constitutional deal is through our elections, through electing public officials who swear to uphold the Constitution. When we think the legislature, executive, or courts are not doing their constitutional duties, we can pick other people to hold those offices. But another way, and the critical way in our democracy, that we hold our government to that constitutional deal with we the people is by going to court, to challenge the laws that the legislature passes or our executives or law enforcers take. Sometimes that happens as a defendant, where you're accused of a crime and you defend the case by saying the police violated your constitutional rights by, say, conducting an unreasonable search. And sometimes Montanans can challenge their laws by being plaintiffs, by bringing the case themselves, not defending the case, such as when the legislature passes a law that you think violates your right to privacy. That's what's happening in this case. Ms. Donaldson, Ms. Guggenheim, and the other couples argue that the legislature has violated their constitutional rights. And the state has argued that the legislature has acted within its authority and has not violated their constitutional rights. Those are the fundamental questions at issue today. Now, both sides made their arguments to a district court in Helena, and that court agreed with the state's arguments. The couples decided to appeal the case to the Montana Supreme Court, and now both sides have made further arguments in briefs to the Montana Supreme Court, alongside many other organizations, state and national, who have made arguments to the court as friends of the court. So the court has read all of those arguments, and you will use today's hearing to ask the lawyers questions, to clarify those arguments, and to work on deciding which side should prevail. Again, these are not factual disputes and certainly not political or moral disputes. They are legal disputes, arguments based on the Montana Constitution. So let's turn to the case now. Jan Donaldson and Marianne Guggenheim and 5 other same-sex couples are in committed, intimate relationships. These couples and others in Montana have been together for years, sharing homes and in some cases raising children. Like other committed couples, they have taken steps to plan their lives together through jointly owned property, health care directives, and estate planning. Unlike married couples, however, they cannot take advantage of various public benefits offered by the state, such as tax benefits, certain rights to medical decision-making, and even, as they pointed out in their complaint, shared hunting licenses. And they are also not protected by state laws that protect married couples in the private market for insurance or employment. Montana limits these benefits to married couples. Now, while some states have adopted so-called civil union or domestic partnership laws that provide such benefits, the same benefits accorded to married couples to unmarried same-sex couples, and some states have allowed same-sex couples to marry, Montana has not adopted civil unions or same-sex marriage. None of this is in dispute. So, given those facts, this situation, these stories, let's turn to the legal arguments that are in dispute. These couples claim 2 primary violations of their constitutional rights. First, the couples claim the benefit laws deny them their constitutional right to equal protection of the laws. An important example of this equal protection right you'll hear discussed today arose at this university in the Snetzinger case. In that case, the Montana University system had a policy of not just providing benefits to married couples, but also providing benefits to unmarried domestic partnerships, but only opposite-sex domestic partnerships. The Supreme Court held that equal protection of the laws means that if the university is going to give benefits to unmarried opposite-sex couples, it must either get rid of those benefits or extend those benefits to same-sex couples. In this case, the court will consider, and the lawyers will ask the court to consider, whether that principle applies to this case, whether it would require equal benefits for married opposite-sex couples and unmarried same-sex couples. And the couples argue it does. They argue because there's no relevant difference between opposite-sex and same-sex committed couples. The state argues it doesn't because the state argues marriage is a relevant difference between opposite-sex and same-sex couples. Now, as the court considers this question, you'll hear some argument about how suspicious the court should be in looking at laws that draw a distinction based on marriage or sexual orientation between married couples who are opposite sex and same-sex couples who are unmarried. The couples argue that the court should be highly suspicious because of the classification involves gays and lesbians, a class of people who have historically suffered prejudice. The state argues the court should not be suspicious because the relevant difference here is marriage, not sexual orientation. So that's the equality issue. The second primary issue, and there are other rights at issue, is individual privacy. Individual privacy under the Montana Constitution can only be trumped by a compelling state interest. And an important example of this privacy right you'll hear today is the Grisand case. That involved Montana's deviant sexual relations law, which said that sexual conduct between opposite-sex partners was legal, but sexual contact between same-sex partners was illegal. The Supreme Court held that that law violated the same-sex couple's privacy rights to sexual conduct, and that the state had no compelling interest to outlaw it. So again, the attorneys will ask the Supreme Court today to consider how that principle applies here. The couples will argue that that principle applies by denying them public benefits based on their private conduct, their constitutionally protected private conduct. The state argues that the privacy principle does not apply because privacy is a negative right to be left alone and not a positive right to public benefits. Now, there is a third key constitutional provision, other than these 2 constitutional rights of privacy and equality, that will come up today, and that is the Marriage Amendment. In 2004, Montana has amended our Constitution to provide that only a marriage between a man and a woman is valid or may be recognized in this state. Now, the state argues that this provision prohibits the court from extending marriage benefits, and married couples are the only ones who get these benefits currently under Montana law, under the Constitution, even though the state concedes the legislature could create a separate class of benefits of civil unions or domestic partnerships. Now, the couples argue that this provision only prohibits the state from calling benefits for same-sex couples marriage, but that other than that designation, the marriage amendment imposes no limitation on their other constitutional rights to equal benefits. So those are the key constitutional rights at issue. One last thing you'll see discussed today is the question of separation of powers. Our Constitution gives the legislature the legislative power and the courts judicial power, and they may not exercise each other's powers. Here, if the court agrees that Montana law violates the couple's rights, they'll ask the court to tell the legislature, among other things, to tell the legislature to extend married couples' benefits to same-sex couples. Now, the state says that that is an exercise of the legislative power to extend the law rather than striking the law down, as the court often does in other constitutional cases. The couples say that it is an exercise of the judicial power, which is classically defined as the power to say what the law is, and in the couple's view, tell the legislature what the law requires. So those are the four main points that may come up today. And as you'll see, this case presents fundamental questions of equality, liberty, and democracy under our Montana Constitution. So let's get started. Because the couples lost in the district court below, they are the appellants and will argue first and last. They are represented by attorneys Jim Getz from Bozeman, Betsy Griffin, and John Ellingson from Missoula. The state is the appellee and will argue second. The state is represented by Assistant Attorney General Mike Black of Helena. After hearing the arguments, the justices will meet, discuss the case, vote on which side they think should prevail, and assign opinion writing duties. And in a few months, if the justices are unanimous, there will be one opinion written by one justice for the whole court. If the justices disagree, whichever outcome is supported by 4 of them will prevail. There are 7 justices, and you need a majority of the justices. In that case, one or more justices will write separate opinions, either concurring because they agree with the result but have different legal reasons, or dissenting or disagreeing with the result. I'll remind you that as we get underway, this is an official judicial proceeding, so please remain silent and seated during the arguments. And please turn off your mobile devices. The clerk of court, represented by Deputy Clerk Rex Rank, will begin the proceedings, and Chief Justice Mike McGrath will introduce the court. I want to conclude by thanking the Montana Supreme Court for sharing these important proceedings with our School of Law, the University of Montana, and the Missoula community, and thank all of you for joining us today.
This is cause number 11-0451, entitled Donaldson et al. Versus the state of Montana. Are counsel ready to proceed? Mr. Getz.
May it please the court, my name is James Getz of the law firm of Getz, Gallick, and Baldwin of Bozeman. With me at council table is Betsy Griffing, former counsel of the Montana ACLU chapter, and John Ellingson, current counsel. And here in the first row are other counsel, Elizabeth Gill of the ACLU of Northern California, my associate Ben Alke, and several Morrison Forster lawyers. I can't pronounce Anand's last name, so I'll just say several of them. They've worked very diligently on this case, and it's my honor to speak for them and for the courageous plaintiffs in this case. The plaintiffs are 12 Montanans who have been active in their communities, churches, and schools. They are 6 same-sex couples. They're involved in loving, committed, intimate relationships. Like different sex couples who marry, they support each other, live together as families, and many of them raise children and grandchildren together. And yet, in the words of Justice Nelson's concurrence in the Snetzinger case, they are ridiculed, despised, demonized, condemned because they are gays and lesbians. This case is brought for the purpose of ensuring that these Montana citizens, like every other Montana citizen, that these are treated fairly under the law. Now, I want to get right into it. And I start with the deepest respect for Judge Sherlock, who I think is one of the best judges we have in this state. But it doesn't mean that he's right every time. And I prepared an oral argument handout, supplied it to opposing counsel, and it's yellow covered. And if I could ask the court please to look at page 1, and I'll emphasize that the titles like straw man and the failure to address 1 and 2 are my additions. I've dissected the order of the district judge. And so what he did in 5 parts, number 1 on page 1, is that he characterized the remedy that the plaintiffs seek, citing paragraph 7, and I'll come back to that. Second point is, and I characterize it as the failure to address the constitutional questions. Plaintiffs posed a number of very serious fundamental constitutional questions in this case, and what District Judge Sherlock said on line 24 from the order page 2, that's my page 1 of the handout, is the court finds itself quite sympathetic to the plight of plaintiffs. That's what the court said about the substance of our constitutional violations asserted. Then we go to point number 3 on page 2 of the handout, which I've characterized as the failure to resolve the limited scope of the marriage amendment. And here's what the court said there. The court should note that it does not particularly feel that the marriage amendment standing alone bars the relief plaintiffs seek. Now, I remember as a younger attorney before the late W.W. Leslie, and I asked a question, don't remember the case, about how somebody feels, and he said, "Counsel, what difference does it make what somebody feels?" Rephrase the question. And here, the point is, the question is, does the marriage amendment preclude the relief requested, or does it not? If it does, there's no case. If it does not, plaintiffs have a case. So it's not satisfactory, not appropriate to say the court does not particularly feel that the marriage amendment bars, but then goes on and kind of uses the marriage amendment in point 4 when he fails to address our claims for declaratory relief.
Mr. Getz, would it be fair to say that the marriage amendment defines who can be married without defining any incidents, pro or con, of the marriage relationship?
Yes, and I'll get to that in more detail in a few minutes, Your Honor, but yes, I would say that. So Judge Sherlock found that this would be an impermissible sojourn into the powers of the legislative branch, even though he acknowledged that the Supreme Courts of Vermont and New Jersey have done precisely this thing, so there is precedent for it. But he, in the end, found that this would violate the constitutional separation of powers, so he dismissed under point 5. Now, I want to return, if the court would, to look at page 1. And I've labeled that the straw man. And the reason I do that is because look at what he says. But before you do that, please look at page 3 of my handout, which has the one-page prayer for relief in our complaint. Now, paragraph 1 asks for a declaration. Paragraph 2 asks for a declaration. Paragraph 3 asks for a declaration. Through 5 claims for declaratory relief. Only when you get to paragraph 7 is a more drastic relief, that is an order to the legislature requested. This is our prayer for relief, and I was always taught that you should be generous when you request your prayer for relief. And I was always taught that courts would sort out which would be appropriate and which would be not. And so if you then go back to page 1, which I call the straw man, for some reason, the district judge focused only on paragraph 7 of our prayer, the most drastic request for an order. He says the prayer for relief requests, quote, an order requiring the state to offer same-sex couples and their families a legal status and statutory structure, and so on. Accurately quotes paragraph 7. But then what does he do? He embellishes that even by saying, in other words, plaintiffs seek an order of this court requiring the legislature to adopt a civil union or domestic partnership statutory scheme. We didn't request that. It is a permissible and possible remedy. It was discussed, but certainly not the only remedy, and that's why I say this is set up as a straw man. And I always thought that the courts were here, particularly in constitutional cases, to ensure that the Constitution is upheld, to ensure that constitutional questions are addressed. And so if you go down to point 2 of my handout on page 1, where I characterize it as a failure to address the constitutional questions, where the court, all it said is a failure, the court finds itself sympathetic. We briefed and argued strongly, as we have in this court, whether there's a violation of equal protection, what is the state's justification, whether it survives rational basis review, whether suspect classifications apply, whether fundamental rights of dignity and privacy are involved. And what does the court do with those? The court says it is very sympathetic to the plight of the plaintiffs.
Mr. Getz, don't you think that perhaps the district court would have treated it differently if you'd have filed a direct challenge to specific statutory provisions, say the contract provision under contained in Title 40?
Well, that's a good question. I don't know, because if you follow what the court said...
Well, I did, and it seemed to me that is what the court said.
Well, that's one of the things the court said, but the court also said this is a violation of separation of powers. And why is it not a violation of separation of powers to select one issue, one statute, litigate it, and then trammel into the impermissible sojourn of legislative powers?
Well,
but I
because
think
in those cases, the legislature has acted. In this case, the argument is the legislature has not acted.
No, unless I misunderstand your question, the broad array, the scheme that we're talking about, in all cases, the legislature has set up policies that are dependent on spouses or family designations. So the legislature has acted. What they have done is discriminate against committed same-sex couples. And so I think your question was, would he have done the same thing if it's a simple challenge to one of these provisions instead of all of them? Maybe I misunderstood your question. And the answer is I'm not sure, because if you follow his separation of powers logic, it applies, I think, equally to one as to all. Now, in fairness, without really articulating, I think his separation of power problem was that, you know, we're really biting off too much here. It's more than the court can chew. But that's not a separation of powers problem. In my view, we've had, for example, in 1989, I handled the case before this court, Helena Elementary District Number 1 v. State. We had a very complicated system of school funding. It took us 6 weeks to try that case. And the court did not hesitate to apply the equality of educational opportunity. That was impact litigation.
Well, the state argues the distinction between those cases is there's a constitutional provision that directs the legislature to establish a school system. There's no similar constitutional provision that directs the legislature to establish a system of benefits for public employees.
Two answers to that, Your Honor. First of all, you're thinking perhaps of Columbia Falls Elementary District, which you were the counsel on, Your Honor. I
Hard
recognize.
to forget.
And Article 10, Section 1, Part 3, there says the state shall, or the legislature should supply or provide a basic system of quality education. The legislature shall provide. But in 1989, when I litigated Helena Elementary Number 1, it was based on Article 10, Section 1, equality of educational opportunity, which did not have the same mandate to the legislature. But the second response is, and we've argued it in terms of unconstitutional conditions, we're not arguing that the state must provide, for example, a certain type of benefit to anybody. But if it does, it has to provide it on a non-discriminatory basis, on a basis that would not violate the Equal Protection Law. And that's called the doctrine of, as you know, the unconstitutional conditions. You simply can't condition, for example, the right to welfare on in Shapiro v. Thompson, for example, the court found that conditioning the right to welfare violated the right to travel. In LaFleur, Cleveland Board of Education, it held that you can't preclude pregnant women from teaching because that violates your right to procreation.
Mr. Getz, to your knowledge, is there some constitutional or judicially enforceable mandate to the legislature that decrees that the legislature cannot provide benefits to same-sex couples?
Not at all. And Your Honor, if you would turn, for example, to page 7 of our handout, and this is apropos of the state's argument that the marriage amendment somehow directs this discrimination to spouses based on spouses, or that it precludes what we're requesting. But here's a concession from the state in its district court brief. Nothing in the marriage amendment would prevent the legislature from creating a separate classification of domestic partnerships. Indeed, the state has done that. If you look at page 8 of the handout, it's the Declaration of Domestic Partnership Relationship form of the state of Montana that they use. And you see further concessions. As a policy matter, the legislature could create a different status conferring similar benefits outside of marriage for civil unions or domestic partners. In other words, the marriage amendment, which is the only potential arguable obstacle the state has asserted, simply does not preclude the legislature from providing these benefits.
But Mr. Getz, I think the state's argument is that by the sweeping relief that you've requested, the granting that relief would eviscerate meaning from the marriage amendment and relegate it to a matter of mere nomenclature or symbolism. How do you respond to that?
Well, I respond to it, the state is wrong on that point. It's not mere empty symbolism. And I only have to point the court to the rash of litigation. For example, Perry case in California, where they're litigating the right to marry even though they have same-sex benefits. And the other states like Connecticut, the Kerrigan case. You know, marriage...
Well, excuse me, if the marriage amendment precluded benefits, then the state could provide no benefits. These domestic partner benefits that the state does provide would be unconstitutional. They'd be precluded, wouldn't it?
Exactly. And that was my point in citing these cases. But nevertheless, does it relegate to empty symbolism? The answer is no. Marriage is not about a permit. It's not about these benefits. I would ask this court, would anybody on this court trade its status of marriage for the status of domestic partnership? The answer is no. So my point, Justice Baker, is that marriage still has significant meaning. It's not about a permit. But these plaintiffs cannot get married because of the 2004 amendment.
Let me follow up on that, counsel. You say that it would still leave marriage under the marriage amendment with significant meaning. But all that I've heard so far is that it's a significant meaning in terms of how one may view it or the importance one may attach to it. But is there anything concrete in the law that would be left other than this personal feeling about it?
What is left that's concrete in the law is that these people cannot get married. And I guess I disagree with the premise of the question. How people view it, how symbolic and how important and how solemn it is important. Marriage is meaningful.
But in what way? I'm trying to understand what concrete in the law is left. When you say it's still significant, what is the significance?
The significance is that you're married. And I pose this question again, Your Honor. Would you trade that status for 1 minute for the status of domestic partnership? And I would be audacious enough.
I prefer not to answer. Yes.
Yeah, I would be audacious enough to answer for you. You would not,
we get to answer,
nor would
ask
I.
the questions.
Well, and I understand, but see, it seems to me that that's based on my personal perception about the importance of marriage. And I'm saying, is that all that is left under the marriage amendment if we grant your relief?
Well, it's certainly important enough to trigger all this litigation in other states, the importance to people, the importance to my client. If you characterize that as that's all that's left, I guess that's one view, and I think there's a parallel view, and that is marriage is very, very important to those people who have access to it. And moreover, if you look at the marriage amendment itself, all it says is that only a marriage between one man and one woman shall be valid or recognized as marriage in this state. What I think your premise, Your Honor, is, with respect, is that somehow this is more. I mean, what else in the law does this language guarantee you except that marriage is between one man and one woman? And isn't the role of the court to interpret the law as given? The words, those are the words. You have in our briefs the history of what are called marriage plus amendments that were in effect in Louisiana and Nebraska in 2004 when Montana passed its, and there have been many since. Those marriage plus amendments go beyond and say much more than what we said in Montana and what Alaska said. And so I think it would be improper to try to search for some additional language in that amendment that somehow guarantees other legal rights. I think the premise of your question, therefore, based on the stark language, is incorrect with respect.
Counsel, I want to move the football down the field a little bit. In the Vermont and New Jersey cases, which you cite for the proposition that the court can indeed declare these rights and direct the legislature to do something to implement them, in those cases, the way I read them, in both cases, the court expected the cooperation of the legislature, and indeed the legislature acted in accordance with what the court directed. In this case, if we enter the declarations that you ask us to enter, and the legislature does not act, what then?
Well, that's where the whole question of gradation of relief comes in. It's always, I think, the correct approach to start with the least intrusive approach, which is the declaratory judgment approach. And as in my handout, I've cited the Powell v. McCormick case, where it says specifically that this is on page 5, I think. It says, a court may grant declaratory relief even though it chooses not to issue an injunction. And that's what the court should do. And then it says, we need express no opinion about the appropriateness of coercive relief. That's the way it should be done. You can grant declaratory judgments whether or not there's other relief available. If the legislature, in response to your question, does not act, time enough to do something. And this court has, of course, a whole broad range of powers, including injunctive powers if necessary, including, in some cases, there's precedent for ordering taxes in local government cases. But that's a long way off. We should not presume that the legislature won't do its duty. In Columbia Falls School District case, they asked, somebody asked that the court define quality education. This court declined to do that, I think appropriately, and said the legislature should do it. Is there any evidence that the legislature won't do its duty there? In my earlier case, elementary, they wanted some definition of what the level of the foundation program should be. The court declined to do it. And yet things worked out.
You started off by referencing the Vermont and New Jersey decisions as an example of what this court should do. And yet you've said it's not necessary to enter the relief that you've requested in paragraph 7 of your complaint, but simply a declaratory judgment. What's the difference between, I mean, if we do enter a declaratory judgment, aren't you suggesting that we should direct the legislature to act?
I don't think so. I think you should be more subtle than that, and that subtleness is simply a declaration. For example, we ask in the prayer for relief paragraph, or page 3, a declaration that the state's failure to offer same-sex couples equal opportunity to obtain the protections and obligations that are available to different sex couples through the status of legal status of marriage violates the right to equal protection. I mean, the order does not have to be any more complicated than that. The order could be quite simple. And while there's an array of statutes that might be affected, that's the job of the Legislative Services Department. But your order does not have to be complicated. It may have to be complicated if, in response to Judge Cotter's question, the legislature then does not act. And of course, they didn't act in Grayson, but that was a self-executing. When this court struck down the sodomy law, the deviant sexual conduct as it applies to same-sex people, 14 years ago, which indicates, by the way, the hostility of the legislature. The legislature didn't act, but no prosecutor would ever violate the order of this court, so that was self-executing. If this legislature has to face the broad array of these statutes, I believe it will act, as it did in the school cases.
But counsel, if it doesn't, really it takes us back to what Judge Sherlock was talking about. You'll have to bring cases on a statute-by-statute basis when they're violated, won't you?
Well, or you'll have to bring another impact suit and seek more coercive direction from this court. And that sometimes happens.
Coercive or maybe more specific? I mean, you talk about Greisen case, but that's a case where the legislature had acted and this court exercised judicial review over a legislative act, a specific act. Here, we don't have any specific acts that you're challenging.
We have a whole scheme of acts.
You have a scheme, but you have not listed a specific act saying, for example, back to my earlier question, 40-1-401 says that a contract for a civil relationship is void. You haven't challenged specifically that statute.
Well, that's because, I mean, does this court really want the expense and the time consumption? The Kolstad case, for example, on parental rights took 5 years to establish one issue on parental rights. And the purpose of the declaratory judgment remedy, it's remedial in nature, is to eliminate uncertainty. And the answer here is that in any civilized society, you have a system. You have a system of dissolution of marriage, for example. You have a tax system that provides for benefits. You have a public employees retirement system. Is it really so complicated to say that if you don't extend these benefits and these obligations, these spousal obligations to committed same-sex couples in a broad declaratory judgment, is that really so complicated? I suggest that it is not.
Well, or if we simply declare that discrimination based on sexual orientation is unconstitutional, it violates equal protection. That pretty much solved the problem?
That's right. We make no bones about it. This is an impact lawsuit. But let's not, when the state says innumerable, I think it's maybe numerous, but I don't think it's innumerable. And I think that this answer could be relatively straightforward and taken care of relatively quickly.
So counsel, your suit focuses on what would be considered state action because of the nature of the employees involved. What happens if you take this step? Are we going to see these same kind of claims brought against private employers who offer benefits?
Oh, that's a good question, Your Honor. And the answer is that our suit is based on the structure, the governmental structure and state action. Maybe in the future there might be those kinds of cases, but I respectfully submit that we should stick to what's involved in this case, and that is that there are benefits obligations that the state provides in its scheme for a civilized society.
Setting aside for a second the symbolic benefits, is there anything in the record that shows the actual difference in monetary compensation for salary and benefits offered to a opposite-sex couple versus a same-sex couple?
There's nothing in the record that I'm aware of that talks about monetary discrimination salary level-wise.
But no, I'm not talking salary. I'm talking about the salary plus the benefits attendant with that position, to which I assume you're arguing your clients aren't eligible for those benefits. How much are we talking about difference in compensation when you include the salary and benefits?
Well, yeah, the benefits, in some cases they're entitled to the benefits, in other cases they're not. We're trying to equalize that. So to the extent there are not benefits, or to the extent that there's a default provision where only a spouse can obtain benefits, yes, there is that discrimination. That is in the record.
Are you aware of any statute, constitutional provision that monetizes somebody's civil rights? In other words, if you're not getting hit too hard and your rights are violated, that's okay?
No, and of course there shouldn't be. That's not a monetization issue. This is much more important and much more sacred than money. So I respectfully submit, I want to save some time for the rebuttal, but Your Honors, I've on page 4, I cite the Mitchell case on declaratory judgment. And at the end, it says, "The first business of courts is to provide a forum in which the constitutional rights of all citizens may be protected." That is the first business. And then on page 6, I cite Grayson, which is very eloquent when it says, "Simply because the legislature has enacted a law that may be a moral choice of the majority, the court are hereafter bound to simply acquiesce. Our Constitution does not protect morality. It does, however, guarantee to all persons, whether in the majority or in the minority, those certain basic features and rights which are set forth in the Declaration of Rights." And I respectfully submit that this court, its obligation is to be the sentinel guarding constitutional liberties and rights, and not the technocrat. I respectfully understand judicial restraint. I understand separation of powers. But we should not exaggerate when it comes to the fundamental rights that we're talking about here, and we should not forget Marbury, that it is the duty of the courts to interpret the law. With that, I'll save my 10 minutes for rebuttal.
Clerk advises me you have 9 minutes for rebuttal, Mr. Gatsby. I'm sure you'll honor that. Mr. Black.
Good morning. May it please the court, counsel, my name is Mike Black, representing the state of Montana.
Can we just clarify something up front? As is noted, the Montana Constitution says that only a marriage between one man and one woman shall be valid or recognized as a marriage in the state. That's commonly referred to as the Marriage Amendment. And you acknowledge that on its face that would not preclude the legislature from enacting a statute authorizing civil contracts or civil unions. Is that correct?
That's correct, Your Honor. And that is a very important distinction here.
Well, wait a minute. I want to make this perfectly clear, too. The plaintiffs did not ask the legislature in this suit to authorize civil unions or anything such thing. This is strictly a benefits action, isn't it?
Well, it's a benefits and obligations action. I mean, and that's part of the problem, Justice Nelson, is that given the way this complaint is structured, the normal ways that we attack constitutional challenges or defend constitutional challenges is entirely up in the air. Every statute is presumed to be constitutional.
Okay, well, let's talk about that for just a minute then. Aside from the fact that, at least in my view, the plaintiffs have not asked to attack every statute, and you seem to think that's a problem. But in 2009, the legislature passed House Bill 37. It was called an act gender neutralizing and conforming Titles 10 through 90 of the Montana Code annotated current bill drafting standards and amending sections and so forth. This single act, the text of which began at page 295 in the 2009 session laws and ended at page 1262, amended 2,876 statutes. Now, are you asking this court to believe that if the legislature could identify 2,876 statutes that needed to be general neutralized, it couldn't identify a lesser number of statutes that need to be sexually orientation neutralized?
No, Your Honor, I'm not saying that they can't do that. I think that the concern that we have is that when you are attacking constitutionality of statutes with respect to whether or not these particular statutes either violate equal protection or some other fundamental guarantee under the Constitution, that the way we conduct constitutional litigation is to look at the particular statutes. Now, the power of the legislature...
There's 1,000 statutes out there. These people have to file 1,000 lawsuits to get their civil rights?
Not necessarily, Your Honor. I mean, certainly the way that constitutional litigation typically proceeds, in every case, that has been cited to this court that I'm aware of at least has a specific statute that they're attacking or a discrete statutory scheme. We're not talking about a statutory scheme here. We're talking about a statutory smorgasbord. What we have is attached to the motion to alter or amend the judgment an 8-page list of statutes. Some of them are statutes, some of them are definitions for entire sections in 5-point font. Some of those statutes may implicate different standards of review than other statutes. For example, on the first page, there is a statute involving whether or not service people overseas or their spouses have certain rights to vote. Now, we would all recognize that the right to vote is a fundamental right in Article 2 of the Montana Constitution. If that particular statute were attacked in litigation, it would be a different inquiry than another set of statutes on that first page having to do with alcohol and tobacco. Now, alcohol and tobacco regulation are typically under the police power. That's not involving a fundamental right necessarily. And both of those statutes listed in that listing of statutes are just definitional. There is no attempt in that listing of statutes to try and figure out which of those statutes the definition causes the problem. And that's the difficulty here in responding to this lawsuit, and I think it was the difficulty that Judge Sherlock embraced, or probably didn't embrace as effectively as he could have, but it's what he faced.
Mr. Black, given that concern, Mr. Getz has said he would be satisfied, if I understand him correctly, with a ruling that declares that discrimination on the basis of sexual orientation is unconstitutional. Do you agree that it's illegal for the state to discriminate against someone based on their sexual orientation?
Do I believe it's, well, I don't know if the state takes a position that it is legal to discriminate based upon sexual orientation. I do believe that in certain circumstances, such as in the Grayson case and in Snedeker, there are constitutional problems with some of the regulations or statutes. The difficulty with that type of a pronouncement from this court granting declaratory relief is it is essentially an advisory opinion.
It would be advisory if we said that gay committed same-sex couples are entitled to equal protection of the laws. That's advisory?
Well, I think it's advisory in the context if we're not applying it to specific statutes, Your Honor. I mean, and that's the difficulty with the nature of the relief that's sought here.
So the state's position is, I guess, you seem to deny this, I don't know where you are on this. In order for committed same-sex couples to obtain the basic civil rights that heterosexual couples have, married heterosexual couples, they have to file a suit by suit by suit by suit by suit approach.
Well, I think it's going to take more than one lawsuit, Your Honor. And it's going to take more than one lawsuit like the one that's being presented here. And I'll give you a concrete example that I think frames the problem for declaratory relief. Because as we know, granting declaratory relief is discretionary. And a court is not required to grant declaratory relief, particularly where it will not end the dispute. And the one situation that jumps out to me, and I don't do family law anymore, and I wasn't very good at it when I did it, but part of the statutory smorgasbord that plaintiffs are attempting to invalidate are some of the family law statutes. What type of guidance are we giving to the district courts in Montana? For example, if you have an action for legal separation and there's an issue of maintenance, what standards are there with respect to what type of a committed relationship do you have to have?
But counsel, Mr. Getz is asking this court for incremental relief, for at a minimum a declaration, as he suggests, that it is unconstitutional to discriminate against the plaintiffs and others based on their sexual orientation. Given that incremental approach and then deference to the legislature as to how to correct those inequities, why is it preferable to do nothing than to do something? To start the process?
Well, I certainly think that whatever opinion comes out of this court will start the process. The problem is what type of an order are we fashioning and what would it look like? To grant the broad relief sought by the plaintiffs, I would submit, is nothing different than an advisory opinion. What you're being asked to do is make a pronouncement of policy.
So what should this court do? Nothing?
I believe this court should affirm in all respects the trial court.
Well, then nothing happens. We're back to square one.
I don't think so, Your Honor. I don't think so, Your Honor, because by virtue of however you fashion the order affirming the trial court, we're moving forward. I mean, I understand and I agree with Mr. Getz that this court and all courts are sentinels of our liberties and our rights. But it's also true that oftentimes incremental change is the way we get from A to B.
Well, again, I'm really confused about what your position is because I don't think you stated this in your brief. But let me try to understand where you're coming from. Do you believe that committed same-sex couples are entitled to equal protection of the law? Do you believe that?
It would depend upon the circumstance, Your Honor. They may or they may not. And that was the point I was trying to make with respect to the voting statutes versus the alcohol and tobacco statutes. When we're looking at claims with respect to...
What has tobacco statutes got to do with this? We're talking about basic civil rights.
And that could be...
Well, they don't have the right to smoke or what?
Well, that's my question, Your Honor. I've got 8 pages of 5-point font identifying statutes that they want to take judicial notice of, that they want a declaration regarding constitutionality or unconstitutionality. And a definition of immediate family members, which includes spouses, is part of that. And that is the problem here. Now, if we're going to talk about equal protection, I do believe, and the state does assert, that the marriage amendment does identify a discrete constitutional class that takes it out of strict scrutiny. That, I believe, is something that this court does need to address here, because all constitutional provisions must be harmonized to the extent that they can be.
How does the marriage amendment take it out of strict scrutiny? How does the marriage amendment take it out of strict scrutiny?
I believe because part of what happens here is you have to identify whether or not there's a suspect class. And by virtue of the marriage amendment, as we've argued in our briefing, the suspect classification, the classifications here are married and unmarried, not same-sex versus opposite sex or something beyond a couple. The Constitution provides that a distinct status is afforded by the marriage between one man and one woman.
But counsel, the problem with that argument is you're going to define who can get married, offer benefits only to married people, and a large group of non-married people can meet the standard by getting married. Others have no opportunity. Aren't they discriminated by the system then?
Well, they are treated differently. But is it constitutionally cognizable discrimination? I don't believe so. By virtue of the fact that we can take a discrete circumstance, and that discrete circumstance is whether or not they're provided benefits under a particular regulation or a statute. Okay. Under that discrete circumstance, maybe this court could address what the Alaska Supreme Court did in saying, hey, when the government is acting in its proprietary capacity, this classification doesn't make sense. But with respect to the government acting in its sovereign capacity, we have a broad array of statutes here enacted back a century. It doesn't necessarily make sense to paint it with the same broad brush as to every statute that's presented here.
So your point is when the state is acting as an employer, for example, and chooses to offer these benefits, its decision to exclude certain people from those benefits, the availability of those benefits poses a different kind of problem than if the state acts in that sovereign capacity discussed.
I mean, it certainly does, Justice Morrison, and it really does depend on the circumstance. I mean, we all know the history of civil rights cases and how that change went and how hard it was. And I'm not going to argue whether prior discrimination was good or bad. I mean, certainly it was bad. But even Brown versus Board of Education, Loving versus Virginia, all of those cases dealt with specific statutes or very narrow statutory schemes. The scope of relief being sought here is certainly unprecedented. And it's not going to lessen litigation. I submit to you that it's going to increase litigation, particularly if the legislature doesn't act. And the legislature certainly has the power to act. They're not precluded from acting to provide a domestic partnership or same-sex benefits and obligations type of rationale or statutory construct. But that doesn't mean that they're constitutionally required to do that. And I do think that the issue with respect to seeking declaratory relief here, even though Judge Sherlock may have addressed it more directly in his order, clearly what he's thinking about here, at least as I read it, is that you're asking for relief that really a court acting in sound discretion shouldn't grant, because it's...
Don't you agree that we have to interpret constitutional provisions as to avoid conflict with each other?
Your Honor, I absolutely agree with that.
Okay, and that's what you argued at page 3 of your brief, isn't it?
I believe that's true.
Yeah. The marriage amendment says that marriage is between one man and one woman in order to be recognized and valid. The Article 2, Section 4 of the Equal Protection Clause says that no person shall be denied the equal protection of the laws. Now, while maintaining that gay and lesbian people cannot become married, couldn't we narrowly interpret those two fundamental constitutional rights, the right to equal protection of the laws, to say that while gay people can't become married, the legislature still has to provide the same benefits to those people as heterosexual couples?
Well, certainly,
now, we're avoiding conflict between the two by that type of interpretation.
Certainly, Your Honor, I think that if the court were faced with a discrete set of statutes, that may be an appropriate remedy. I do believe that the way that this is presented presents problems for that. And certainly with respect to the equal protection component and whether or not there's a suspect classification here. I mean, Justice Nelson, as you noted in Snetzinger in your concurring opinion, this court hasn't recognized that same-sex preferences or same-sex couples are a suspect class under Montana law.
Well, yeah.
And I understand, Your Honor, and certainly they may. But the legal environment that we were operating in when the marriage amendment was passed did not confer that type of protection. Certainly, that constitutional amendment is entitled to some weight here. And I think that to the extent that plaintiffs want to attack this entire universe of statutes, I mean, literally goes from Volume 1 to Volume 10 of the Montana Code, that they're really attacking in substance the marriage amendment. I believe that that's certainly true, and their failure to attack in substance the marriage amendment.
How are they doing that?
Because essentially they are wanting this court or any court to afford them the same status as married couples, and the Constitution provides.
But there's no preclusion in the marriage amendment from the state doing that, or employers doing that.
But there's no mandate for the state to do it either.
Well, so what?
Well, but that's where we get back to the distinction.
The fact of the matter is, those same sorts of benefits are being provided now in certain circumstances. And if the marriage amendment actually precluded that, as you seem to think it does, then those kinds of laws are unconstitutional. And the state shouldn't be doing that.
No, I think that the argument is much more nuanced, Justice Nelson. And I'm not trying to be tricky here. I mean, I think that the point really is there's a distinction between legislative power and constitutional mandate. The legislature has the power to do a number of things that it may deem to be in the best interest of the people of Montana. That doesn't mean they're constitutionally mandated to do.
Okay, the legislature in enacting Section 3320.13.13 actually did include sexual orientation as a basis for non-discrimination in that statute. So I guess you're saying that under the marriage amendment, that statute's unconstitutional, legislature can't do that. There was no mandate.
No. No, what I'm saying is they still have the power to enact that type of legislation. They're not constitutionally required to enact that type of legislation. And that's certainly where I think that counsel for appellants and I disagree.
Well, if we get back to interpreting the marriage amendment and Article 2, Section 4 together narrowly, isn't there a mandate that gay people that gay people have the benefit of equal treatment of the laws? Isn't that a constitutional mandate?
All people have the benefit of equal treatment of the laws.
Good. I'm glad that, even gay people?
Well, sure, but the question is whether or not.
Well, see, we've made some headway.
Well, you know, and I mean, this is a very narrow issue in my mind, and that is because what we're attempting to do is figure out, you know, how, as a judiciary and how, as a society, we proceed toward progress. And certainly under the Constitution as it's presently written, given the marriage amendment, it does not appear, in my mind, and as the state has argued, that the plaintiffs in this case are a suspect class for equal protection purposes. Now, it does satisfy the rational basis test. As a matter of fact, when we talk about the dilution of the marital bond.
Well, counsel, in that regard, how would you distinguish the Alaska case, which applied rational basis to the aspect of Alaska, the government being an employer?
Well, certainly what the Alaska Supreme Court said is that we're able to harmonize here because of the narrowness of the issue that's presented to us. That we are looking at the state of Alaska and the city of Anchorage, I believe, in their capacity as employers offering benefits to couples that in that situation appeared to be treated differently as part of the same class. They did not purport to go forward and say that as a matter of sovereignty, that all statutes that purport to treat those classes unequally or those people unequally are unconstitutional and do that.
Well, let me go back to the suspect class definition. There was a case in 1973 called Frontiero versus Richardson. I don't know if you're familiar with it or not, but certainly sexual orientation was not the subject of that case, but suspect classification was. And the court said that, and I quote, the characteristic that they were dealing with frequently bears no relation to ability to perform or contribute to society. Statutory distinctions that have the effect of invidiously relegating an entire class to inferior legal status without regard to the actual capabilities of its individual members, that constitutes a suspect class. Now, is it the state's contention that gay people don't perform or contribute to society?
Absolutely not, Your Honor. But the predicate to the question is invidious discrimination. And that's why it's important to look at specific statutes, because when we're looking at suspect classes, outside of the issue of powerlessness, we're talking about purposeful treatment. And certainly with respect to the vast majority of the statutes at issue here, to the extent we know which ones they are.
Doesn't the federal constitutional law identify invidious discrimination as a history of discrimination? It doesn't focus on any one particular incident. It doesn't even focus on political gains that the suspect class may have, but it focuses on the history. And wouldn't you concede that gay people in this state, if not this country, have historically been discriminated against and demonized and treated like inferior second-class citizens?
Your Honor, as you know in our briefing, we concede that there have been a number of horrible things that have happened to gay people. Yeah. The focus on discrimination is on state action, and granted, there are some issues here in Montana, like the Grayson case, where state action was involved. But not all of this involves state action. A lot of the concerns of the plaintiffs involves private action. Now, granted, this court has the role of trying to figure out, how to apply our Constitution to private action at times. But again, I go back to the concern that how do we rationally address these issues?
Well,
And-
Article 2, Section 4 prohibits private discrimination too, doesn't it?
Yes, it does in certain circumstances, Your Honor. You're right.
Right.
I mean,
On certain named classes of individuals. And sexual orientation is not included in those groups.
that's
Now,
exactly right.
If you agree with me, and I guess you do, I don't know, that people do suffer discrimination on the basis of sexual orientation, why shouldn't that be included as a suspect class prohibiting discrimination against this group?
And I believe because the way that the class is defined, at least under the Montana Constitution, is it's not based upon sexual orientation
What is
or
it
even
based on?
couplehood. It's based upon whether you're married or not married.
Counsel, we're here on a motion to dismiss. Was there anything to be gained by developing the record further with respect to these claims?
Well, it depends. I mean, one option that could be gained, I mean, obviously the plaintiffs are the master of their own complaint. It's not up to the court to determine, whether or not the complaint is pled in a way to deal with specific statutes that haven't been pled. Certainly, if the plaintiffs on remand were allowed to amend their complaint to add specific statutes, I do believe that there would be an opportunity to more fully develop the record so we can actually confront those specific statutes and in the manner that we normally deal with constitutional litigation, put the burden where it properly belongs, and that is on the people attacking the specific statute. And I'm sure that counsel has thought of specific statutes he may want to include, and I think that may be one way to deal with this issue. But as we're presented here, certainly the state moved to dismiss based upon the pleadings, and there are no disputed issues of fact.
Well, if gay people are entitled to equal protection of the laws, why shouldn't the burden be on the state to be out enforcing their civil rights? Why should it be their burden to have to file God knows how many lawsuits attacking statute by statute by statute, which is what you're contending? If they're entitled to equal protection of the law, why isn't the state's burdens to be defending them?
Well, I don't think the position of the state is that they're entitled to equal protection of the law under all circumstances.
Wait, you're saying that they're not entitled to equal protection of the law?
Well, all people are entitled to equal protection of the law. The question
Including gay people?
Absolutely. But the question is whether they're a suspect class given the particular statutory or regulatory issue that we're facing. And the level of inquiry will change depending upon the statute.
So, counsel, I want to go back to the prayer for relief and your argument that this was dismissed on the pleadings. Mr. Guess argues there were 5 requests for declaratory relief.
Yes, Your Honor.
And the district court didn't appear to address that directly and focus instead on this order requiring the same-sex couples, that the legislature act to provide these benefits. Okay, well, what's the problem with addressing these requests for declaratory relief?
The problem with the trial court?
Yes.
Well, I think it's subsumed in the order that he didn't believe that the declaratory
If he couldn't
relief
give all the relief requested, there was no sense of giving any relief.
Well, because of the nature of the way this action is pled, there's not one specific statute pled in the complaint. There's not one specific statute that's being attacked in the prayer. And by virtue of asking for such grand, sweeping relief, the court granted it. I think that Judge Sherlock probably could have been a little clearer in what he was doing, but I think it's implicit that he was ruling that what you're asking for is an advisory opinion. You're not going to resolve all of the issues attendant to this myriad of statutory provisions, and therefore he exercised his discretion not to grant declaratory relief. Now, certainly, if this court wants a more specific order from the trial court on those issues, and I don't know that you do, you could certainly remand with those sorts of instructions.
Counsel,
yes, Justice Nelson.
you attached the 2004 voter information pamphlet to your brief, and you refer to that at pages 8, 12, and 22 of your brief. Do you recall that?
Yes, I do, Your Honor.
I assume that you did that because you, for some reason, feel the language of the marriage amendment is ambiguous, or else you wouldn't have attached it. So if we consider that voter information pamphlet as extrinsic evidence, don't we have to consider the proponents' arguments in support of CI 96?
Well, certainly the reason for providing the voter information pamphlet was that was information that was in record at the trial court dealing with what the voters were considering potentially to the extent that they were being informed when they were voting. I don't believe necessarily that the Marriage Amendment Act is ambiguous, but to the extent this court finds it ambiguous, certainly all evidence of legislative intent may be considered.
Well, my point in asking the question is the proponent's rebuttal argument, which is in Appendix 1 at page 25 of your brief, asserts, and I quote, that CI 96, the Marriage Amendment, doesn't stop employers from giving same-sex couples the same benefits as their married employees if they choose. So even the proponents to the Marriage Amendment don't seem to have a problem with granting same-sex couples benefits. Well, for some reason, the state still does.
I'm out of time, but I'm assuming I can answer your question. I mean, I think that goes back, Your Honor, to just the distinction between constitutional mandate and legislative power. I mean, certainly our legislature has the power to grant a variety of benefits and obligations to any member of society. That doesn't mean they're constitutionally mandated. So unless there's any further questions, I guess just the final point here, and I think it goes back to the breadth of relief, that really what the plaintiffs are trying to do here is unprecedented. It's sweeping. All statutes are presumed to be constitutional, and they're essentially asking for an advisory opinion. We would request that you affirm the trial court. Thank you.
Thank you, Mr. Black. Mr. Getz.
What do I have, about 10 minutes, Your Honor?
Mr. Getz, would you address Mr. Black's argument there's a distinction between the state's role in proprietary matters versus the state's role as a sovereign with respect to providing benefits?
Yes, Your Honor. First of all, the language of the Marriage Amendment does not use the term proprietary. Proprietary is a kind of an arcane term that is used historically in two contexts: zoning, where the government acts, say in the water tower in the Bozeman case, or in sovereign immunity cases, or in Your Honor's concurring opinion in Delaney v. City of Bozeman, although you didn't use the word proprietary, where the city was kind of getting into private business. Has nothing to do with what we're talking about here. The government provides benefits, it provides obligations, as it should, in dissolution of marriage context and wills and estates. And that's not proprietary, it's not government. That just has nothing to do with what we're talking about here. Plus, it's a very murky concept that's pretty arcane. I might point out, by the way, through all this argument, I still haven't heard a response from Justice Rice on whether he would trade his marriage status for the status of domestic partner. I have no idea, Justice, whether your wife is sitting in the audience or not.
My point was not that I was betraying her, because I would take that girl whether she was Mrs. or Noreen, but...
Your Honors, I think that we should really focus for a minute on this case-by-case issue. And I want to give you one example, and that's of plaintiff Mary Leslie, whose significant other died in a dynamite accident in Big Sky. She was an employee trying to control avalanches. Mary was denied access to the remains of her partner because the coroner said you don't have any rights there under 37-19-904. She was denied bereavement leave by Big Sky. She was forced to sell the home because they didn't have a will, and guess what happens under the laws of intestate succession? She was unable to be a beneficiary under the workers' compensation law She was unable to file a wrongful death suit. The family did it. Plus, the family came in and grabbed half of their savings and what they considered to be their deceased daughter's possessions. Now, what is Mary supposed to do? Go get a TRO to deal with the remains of her partner? Are we really wanting to force persons in that situation to file a case on each of these things on workers' compensation? I'm not even sure some of these would be appropriate, molded appropriately for that kind of relief. And what we're asking here is to avoid that kind of delay, that kind of complication.
Mr. Getz, if we enter the declaratory judgment that you spoke of in your first argument, how would any of that change? And Mr. Black used the example of a situation in court where a same-sex partner, the parties split and she or he comes in seeking a maintenance award. How is the district judge supposed to determine in this period of hiatus what to do?
Well, the answer is nothing's going to be perfect here, but the answer is we need to trust that the legislature will do its duty. That's the first, that is the true separation of powers here. I mean, the legislature, the Bodie v. Connecticut case dealt with an indigent not being able to pay divorce fees, but the case said, I think, made an important observation about the structure of our society. And what it says is, perhaps no characteristic of an organized and cohesive society is more fundamental than its erection and enforcement of a system of rules defining the various rights and duties of its members, enabling them to govern their affairs and definitively settle their differences in an orderly, predictable manner. Without such legal systems, social organization and cohesion are virtually impossible. That's what we're talking about here. Society has provided these benefits and obligations in the marriage context, in the wills context, in the benefits context. And why can't this court, in a fairly simple approach, why can't this court deal with that? The answer is the court does have the power to do that and should. As the state argues, yes, equal protection applies to everybody, but there's no mandate. Well, I beg to differ on that. Equal protection of the laws. No person is to be denied equal protection of the laws. That is a mandate. That is the mandate. Equal protection of the laws. And if you have a system such as described in Bodie, a system that provides these kind of benefits and protections, as we should have. I mean, when we get married, I didn't know what I was getting into, believe me, and
Your wife's in the audience, Mr. Getz.
But all these spousal benefits and protections, we didn't go through a checklist. And so the question, Your Honors, is Mr. Black says in his mind this is a very narrow issue. Well, in his mind it is a very narrow issue, but that doesn't mean it is a narrow issue. Think of, for example, Justice Frankfurter, the late Justice Frankfurter, who died in 1965. If he had had an interview in 1964, and instead of voting the right way on Brown v. Board of Education, he said, by golly, I see federalism issues here. I see a whole lot of separation of powers issues here. And I, being the intellectual restrainist that I am afraid that I'm going to have to vote, even though I'm sympathetic with these black kids and their educational needs. I'm going to have to vote, by golly, against the plaintiffs in that case.
Isn't it true, using that example, that that's precisely what did happen in an entire series of cases that eventually led to Brown v. Board of Education, number one? And number two, wasn't that a challenge to a distinct statute?
It was a challenge to a system of discrimination. I don't think it was a distinct statute, but it is, I agree, different. But my point is broader than that. I mean, my point is that even though this court can articulate, and anybody with good legal training can articulate judicial self-restraint, and it is an important concept, that sometimes legal technocracy is not the important point. Sometimes doing the right thing is more important. And here, I think this court has the choice. I mean, yes, it can be avoided, hopefully a little more artfully than the district judge did it. But that's not the right thing to do here, because the Equal Protection Clause, as I said, provides the mandate. Every citizen has the right to the equal protection of the laws, and we have a general gross system that is denying that equal protection, and please don't escape on some technocratic grounds. Please do the right thing. Thank you.
Thank you, Mr. Getz. Court will now take this matter under advisement, and we will issue an opinion in due course. On behalf of the court, I want to thank counsel for your briefing and your presentations, including the amicus counsel. I also want to thank the University of Montana School of Law for hosting this event, and we appreciate the fact that those of you who are citizens agreed to come out today and observe this argument. Thank you all. We appreciate it.